It's troubling to think about. Again, we may be moving back 30, some people have said maybe 50 years in time. When I consider these particular words and I consider legislation that's before us, and I come to you with a troubled heart. Currently, we have an attorney general who has hired a high-powered private law firm to litigate discrimination claims before him. And it is either a great ignorance or indifference to pretend that Missouri does not have a problem with this discrimination. With regards to whistleblowers, actions on this bill gives immunity to state agencies. These are the very agencies that should be setting the high standards for protecting us all. We must stop this bill from becoming law. My fellow legislators who stand with me recognize this, and we should be transparent and attempt to change the rules to benefit one powerful senator who is being sued for the very kind of degrading discrimination that this bill affects. As a fellow citizen, I would encourage, consider, and reaffirm that our founding fathers envisioned that we hold these truths to be self-evident, that all men, and I emphasize, all men are created equal. And that then, when we look at our Creator, that certain edible rights cover us all. If personal responsibility is not the core of liberty, then what is? If honor and dignity is not the touchstone of true happiness, then what is? And how can happiness be achieved? In respect, personal responsibility, dignity, and honor are important to us all. Then we will oppose this, and we are opposing this, in an attempt to make sure that Senate Bill 43 doesn't move on. And I'd like to turn this over to Representative Steve Roberts.
Thank you. Thank you, Alan, for getting that started. I serve on the committee for the Special Committee on Litigation Reform and listened to hours of testimony addressing how this bill hurts all Missourians. The legislature endeavor to make it easier for employers to discriminate against or persecute employees in the workplace. The law should allow us to hold bad actors responsible. This law inhibits our ability to hold employers who create a hostile work environment accountable. Colleagues from the other side of the aisle who serve on the Litigation Reform Committee agree that there are gross oversights in the bill that need to be fixed. For example, how this bill expressly removes an individual's liability for their actions. Amendments to try and fix this bad bill, but the Speaker gave orders not to let any amendments pass out of committee. The sponsors of this bill pretend that this just brings Missouri up to federal standards, but that is a flat-out lie. It removes individual liability contrary to federal standards. This bill creates one of the most difficult standards to succeed on a discrimination claim in the country. By limiting liability, corporations will not be deterred from committing bad acts. Discrimination should not be the cost of doing business, and when companies engage in this type of egregious behavior, they must be held accountable. This is about the right of all employees to be treated with dignity in the workplace. Sexual harassment in the workplace, discrimination based on age, ethnicity, gender, religion. This bill affects every Missourian. Who can tell that limiting liability is good for Missouri? What's the use in having a law when the enforcement mechanism is gutted? Amending this bill, it becomes part of the Speaker's legacy. This bill closes the doors to the local courthouse. And when the Speaker's constituents find their cases being kicked out of the local courtroom and into federal court, creating an insurmountable hardship for some, he'll have to own this. If they were sincere about bringing Missouri up to the federal standards, we should add a protection for sexual orientation, as some of the federal courts have interpreted the law. I have an amendment to fix this problem, to move Missouri forward onto the right side of history. Years. In Missouri, a person can still be fired for who they love. In Missouri, a person should be judged by their character, integrity, and competence, not whether they're gay or straight. Not gay marriage or any other hot button issue. This is about the right to earn a living. When I pointed out that we could fix this right now, I was told that now wasn't the time. That it's not appropriate to try and fix our state's problems with discrimination with a discrimination bill. There is no provision in this bill that is necessary or helps everyday Missourians. What is now clear to me is that we are worlds away from serving the citizens of this great state when the bills being brought forth are more concerned about protecting the rights of the oppressors over the rights of the oppressed. Thank you all.
Okay, hey guys, sorry, I'm pitch hitting for Gail McCann-Beatty, who couldn't be with us today. I also sit on the Special Committee for Litigation Reform, and I think that all Missourians need to find Senate Bill 43 disturbing for two very important reasons. First, it seeks to close the courthouse doors to victims of unlawful discrimination, and that means victims of discrimination of sexual harassment, not only race, but also religion and their national origin. We have seen time and time again that this occurs. And more importantly, a law like this does not make the behavior go away. We need to be focusing on changing the culture instead of protecting wrongdoers. Second, this bill is sponsored by a senator who actually owns a business that is currently being sued for engaging in unlawful discrimination. That is somehow okay in the General Assembly in 2017. So not only would Senate Bill 43 make it more difficult, if not impossible, for victims to hold wrongdoers accountable for their actions. Its sponsor is someone whose company, if the allegations in the current lawsuit are true, can easily tomorrow resume his discriminatory practices in the future with fear not of being held accountable. That should be an outrage to everyone in this building, that someone who is currently being sued for the very behavior that he is trying to make basically legal, in my opinion. To put it bluntly, the senator's sponsorship of Senate Bill 43 appears to be a blatant example of an elected official abusing his power for his own personal benefit. And even if that appearance of impropriety weren't so troubling, as we've already heard, is troubling indeed. The Missouri Human Rights Act makes it illegal to discriminate in employment, housing, or public accommodation based on race, color, religion, national origin, ancestry, gender, disability, or familial status. It's one of the most important, if not the most important tool we have to combat illegal discrimination. We are seeing this in the news today. We are seeing a Fox News contributor or a former Fox News journalist who has specifically come out against Senate Bills 43 and 45. She is a conservative who experienced some pretty awful sexual harassment. And our job as Missourians and as lawmakers needs to be to help those people instead of to pass laws that are going to make it fundamentally more difficult. Senate Bill 43 would tip the scales of justice firmly in favor of wrongdoers. And as we heard from our colleagues, that includes the individual wrongdoer. So having someone that's been a victim of discrimination, say religious discrimination, say someone is fired for being a Christian, they couldn't have a suit against the person that actually fired them. They could only sue the company under this bill. That's just crazy in my opinion. This bill would tip the scales against victims and set back work towards racial equality in Missouri a good 50 years. In addition, it also removes protections for whistleblowers. In fact, during the hearing on this bill, I specifically asked the sponsor, what about folks that are blowing the whistle on Medicaid fraud? And he absolutely admitted that those folks would no longer have the protections as whistleblowers under this bill. Reason, as taxpayers, we should all be weary of what this bill seeks to do. Thank you.
Now I'd like to open it up for questions, that I'm going to turn it back over to Representative Steve Roberts and Gina Midden to answer any questions specifically on Senate Bill 43.
There have been a lot of very controversial bills that have gone through that committee. Republicans are citing it as tort reform. What is it about this piece of legislation that makes it stand out and is demanding, its own press conference for its opposition?
Right, well, I think Gina, Representative Minton, hit it right on the head. I mean, here you have a senator who's personally invested in this legislation and will personally affect his business and the businesses that he's engaging in. I mean, I think that that's the type of self-dealing that we all want to steer away from.
And I would add to that, unless you are an atheist white male under 40, this bill affects you.
You said that the speaker said that the bill can't be amended. How do you know that, and why would he say something like that?
Oh, I had a conversation with the chair, expressed my concerns regarding the bill, and he agreed that there was an issue regarding individual liability. And several other members on the committee said that the bill was supposed to pass clean without any amendments.
So the chair said that the bill is supposed to pass clean without amendments?
Yes.
And he admitted that there was issues with individual liability? Or?
I expressed my concerns. He liked my amendment, and he expressed that he wouldn't be able to support it because the bill should pass clean without any amendments on it.
Can you explain why it should pass, why someone would want it to pass clean for those outside of the state?
Absolutely. So if we put an amendment on it, the bill will be sent back over to the Senate, and they want this to go through as quickly as they can. And they have no interest in our concerns or addressing the problems that are legion in it.
And what would your amendment have done specifically?
Sure. So I specifically had an amendment to have an amendment that I'll offer today. At one, it will remove the provision regarding individual liability. So right now in the federal standards, let's say you have a manager who engaged in this type of discriminatory behavior or was sexually harassing a woman in the workplace. Right now, you could sue that individual, but this bill, the way it's written, would give that manager immunity. And it goes far-reaching, even further than that, because if you have a company that is based outside of the state of Missouri, you bring that company into your local courthouse because you would attach that manager, and that would destroy diversity. You can keep it there. Now, all these cases will be kicked to federal court. They'll be removed to federal court because you can't attach that person. You can only sue the company. You can't sue the individual. You're not allowed to hold individuals accountable.
What's the distinction between federal court and state court standards for these kinds of things? And is the process tougher in federal courts than it is in state court?
I could probably talk for an hour about all the differences and that. But I mean, I think the main one that we're hearing a lot of talk of is the federal standard is a motivating factor, which is not what this bill uses.
Is the process, though, in federal courts more rigorous than it is in local courthouses or state courts?
It is more rigorous, and for that, I mean, we have two federal districts in the state of Missouri. We have the Eastern District and the Western District. So as opposed to normally, you've got a citizen who might be from Cole County. I mean, they could go to their local courthouse, file the lawsuit there. Here, they're forced to file it in a federal district. And on top of that, it's going to cost them more money because now you have to find an attorney who actually practices and certified to practice in either the Western or Eastern District. So their costs to even litigate these cases are going to increase dramatically. I mean, this is horrible for everyday Missourians.
So you mentioned some changes where that you would want to put back individual liability and that you would also want to add sexual orientation as a protected class. Are there any other changes to the bill that you would like?
Absolutely. I mean, there's a huge problem. I mean, this bill makes exclusive remedy for these types of cases. Anything happening in the workplace. So for example, let's say you have an assault or a battery or some other common law tort. The way this is written, it specifically makes this mechanism the only means to recover in those types of cases.
So in what ways can we strengthen the current legislation as is so that we can kind of bypass what you guys are opposing right now?
I'm sorry, I didn't hear the first part of your question.
In what ways can we strengthen the current law as is so that we can kind of pass what they're suggesting right now?
Sure. I mean, really, what we can try to do is try to stop it and oppose it. I call, ask all my constituents and everything, citizens of the state of Missouri, to call their representative and senator to oppose this when it comes on the floor, and the governor's office as well, because when it makes it to his desk, he'll have the authority to veto this and stop this bad bill.
You mentioned whistleblowers. Would you have offered an amendment? How would you make that section stronger in your opinion?
Well, there again, I could talk for hours about that as well. I will have an amendment regarding the managerial situation. In a nutshell, the bill exempts folks that are in managerial positions that are to report on things. And again, my best example that we used in the committee was about Medicaid fraud. So say I'm a bookkeeper for a nursing home and my job is to chain of command, so to speak, about fraudulent invoices. So I tell my supervisor or I tell the owner of the company, hey, these invoices are fraudulent. We've just sent out 100 requests for Medicaid reimbursement for patients that don't even exist in our facility. And the CEO says, we're sending them anyhow, we're not doing anything. And if I say we need to tell the Attorney General about this, that CEO can fire me and I have no recourse at all.
Is there an exemption about state workers, government workers?
There is also an exemption about that.
Can you get into that a little bit?
Is that in both whistleblower or employment? I think it's just in whistleblower.
Okay.
Yes, it's just in whistleblower. So, you know, the current situation with the Department of Corrections would be a great example. So say I'm a guard that sees all of this bad behavior going on. I mean, we're hearing now about a lawsuit that includes a woman with a disability on top of all of the sexual harassment claims that we're hearing. So again, say that I'm a sort of a bystander of this behavior and I call the authorities. I could be fired under this bill and have no recourse whatsoever for basically doing the right thing. I mean, I think that that's the important aspect about all the whistleblower portions of this bill, is that it really just seeks to penalize anybody that tries to do the right thing, and it's absolutely a disincentive to report wrongdoing, even when that wrongdoing is happening on the taxpayer's dime.
I understand your DOC example, but with the Medicaid example, does this Whistleblower Protection Act, is it only for discrimination claims that you don't, or all?
No, whistleblower is different, and again, it's sort of interesting the fact that both of these things are combined in one bill. But whistleblower has nothing to do with discrimination. Whistleblower has to do with letting law enforcement know or letting the authorities know when somebody is committing fraud or otherwise breaking the law.
My last question is, we've heard many people say that this is, you know, bringing us back to Jim Crow. This is a Jim Crow law. Can you explain that for people who might not understand that terminology?
Absolutely. I mean, the biggest problem, what's the point of having a law if you've got no means to enforce it? If you're gutting the ability to succeed in one of these lawsuits, because these lawsuits are very difficult to prevail on. I mean, they take 2 to 5 years, sometimes even longer, to make your way through the courts. I mean, you need someone who's strong, who can go forward and move forward on these courts. And you've got a bill that's sponsored by a senator and it is designed to make it more difficult lawsuits. I don't see how you can make any legitimate argument that this is fair or good for Missourians. And, you know, I want to give credit to a lot of my colleagues on the other side of the aisle. Some members in that committee, I have an amendment from them in my office that they wanted to submit, but were asked not to file it because they don't want this bill to get sent back over to the Senate.
Okay.
I'm not going to put them out like that. But I can give you a copy of the amendment if you'd like to see it.
It just sort of follows up on that as well. I mean, look, you guys are just as able to find the case, the Tracy Ransom versus Show Me Rent to Own. Read that case and read it if Senate Bill 43 were in effect. And I welcome anybody to tell me that that case would move forward if Senate Bill 43 had been in effect at the time that that lawsuit was filed.
Is this type of legislation being around nationwide, or would this be what you guys consider to be another black eye in Missouri?
It's absolutely a black eye on Missouri. I don't know that any other state has all of these things together. The exclusive remedy, the loss of individual liability combined with the increased standard. I don't know what Steve has to say.
Absolutely. I mean, it is absolutely a black eye state. It moves us backward, especially now with the issues we're just seeing here in Missouri. It's horrible timing, it's completely inappropriate, and it's misguided to say that, oh, we're just bringing us up to the federal standards. I mean, you've got a party that wants to buck the feds on everything. I mean, we're spiting ourselves regarding this whole Real ID thing because we don't want to comply with federal regulations, yet now here we are, the feds got it right, and we want to hold ourselves to their level. I mean, it's ridiculous.
Would this make it easier to fire a woman for being pregnant?
Absolutely.
Well, again, it creates the same standard to the extent that if you're claiming that you are being fired, you're being discriminated against based upon your gender. It makes no difference if you're pregnant or you're being sexually harassed. Let's put it that way.
Can you distinguish between contributing factor, a motivating factor, and demotivating factor? Because I know that came up in
Representative Elbrock, but we need it.
Right, okay, so a contributing factor means that, that reason was the reason for it. So let's say, for example, you're a pregnant woman and you're late to work one day because you had a doctor's appointment. Other people in your office are late all the time, it's no big deal, but they say, well, we're firing you because you're pregnant and because you were late to work today. I mean, you can clearly demonstrate that by them saying you're pregnant, it contributed and that was a part of it, and that shouldn't be acceptable.
And even if they weren't that, I guess, forward about her being pregnant.
Yeah, but just to give you an example of it.
Okay.
And then like with the but-for causation, I mean, that means it was that's something that's only using really negligence cases because it's such a high standard, and they actually try to word it with by the way that they define the because of the language and all that, a motivating versus the motivating. A is more in line with contributing factor because there is a motivation for it. The means it was like the only or sole, more towards that but-for causation standard.
Which is a lot harder.
Oh, absolutely.
It's virtually impossible to prove. We're human. I mean, I've said this to other groups. Raise your hand if you've never once made a mistake on your job. We're human. We all make mistakes in the employment context. Some of them are smaller than others, obviously. But the bottom line is when it says, when you're talking about but-for causation, you're talking about but for the disability or the sexual harassment, you would not be working here. And so think about it. You could be 99% sexually harassed and 1% late, and that firing would be legitimate.
And I don't know if it's more in ignorance or indifference, but to think that racism or discrimination is obvious or in your face, it's not. It's very subtle. I mean, these employers aren't going out and saying, we're firing you because of this. They'll make a pretextual reason. They'll say, well, we're really firing you not because you were late, because your doctor's appointment, it's because you were late today. And that's a legitimate reason.
We also heard testimony in committee, of a white male over 40 who had a pretty bad story, if you ask me, who was basically fired because it was cheaper to hire somebody younger than he is. And these are men and women in the state of Missouri that have families. These incomes are important, and not only are they important for keeping your family, but they're important to go out and buy stuff, which keeps our economy going.
I thought that they amended the but-for standard out of the Senate, and then when it was in the Senate, but you're saying that it's still in there because of the motivating factor.
It's the definition.
It's how they define it. So, I mean, they could have very easily said a motivating factor, but we got the bill with me. They define that part, but then they also define because of language, and they try to shape it so it'll have the same effect as but for. So they're not explicitly saying that, but you can tell that the way to that same point another way. So you'll see it if you look at the definition section where they define motivating factor. And then you'll see where they talk about the because of stuff, and those definitions kind of get at that part. So no, they don't explicitly say, but for, but for.
Because of may actually explicitly say but for.
So the language was changed, but the effect.
A distinction without a difference, I would say.
Representative Roberts, if you were successful in getting your amendment attached, would you consider voting for the bill?
Which amendment? I mean, I think there's still, I've got a huge problem with individual liability. I mean, I don't like the message saying that, we're not going to hold individuals accountable for what they're doing. I mean, also there's that huge issue. We've also have amendments to bring it to what truly is the federal standards, the motivating factor. So I think I would support this bill if they were genuine, actually what the federal standards were, which this bill is clearly not.
Are there any other parts of the federal standard that included?
Oh yeah, well, for example, discrimination cases based on race, there's no damage caps. I mean, this bill very explicitly puts in damage caps. I mean, when you've got some of these huge billion-dollar companies and you put these caps on them, I mean, it's cost of doing business. I mean, the purpose of punitive damage is to deter bad behavior. Right now, we have mechanisms in place to make sure that those are reasonable and not excessive. I mean, if a jury hears that defendant is engaging in egregious behavior and wants to send a message, that's the whole focus of it. So to handicap them and put those limits on there completely gets rid of the purpose of punitive damages.
Going back to individual liability, I think that juries would feel, juries want to punish the people that actually did the harm. Juries want to punish that manager that actually did the firing or did the discriminatory behavior. And I think that if that person is not called into court, I think that juries are going to be confused at a minimum. And we don't have that in the current federal standard right now. The wrongdoer is there, sitting in a chair, and is has to testify.
You mentioned the change language with the same effect because when I was on the Senate side, they said that that was a compromise to make it, in Senator Schue's word, a bad bill less bad. But it's not less bad. It's still bad.
I don't think so, and this is the problem. I think this compromise was at what, 1 o'clock in the morning, 3 o'clock in the morning? This would be Exhibit A, and why compromises at 3 o'clock in the morning might not be the smartest way to go about making policy for Missourians.
Any other questions? All right, well, just to close this out, I mean, the Republican Party has super majorities, both the House and Senate, and they've taken 5 executive offices across our state. It is an awesome power entrusted to them by the people of Missouri, and we see every day how they choose to wield it. Pulling back civil rights and instead changing laws to protect those who violate the right to be treated fairly and with dignity in the workplace is a clear step backwards. This type of behavior creates a stark vision of the shape of things to come for the citizens of Missouri. And opposing this step backwards and just saying that this bill is wrong. Thank you all for being here.